And we want to hear your question. So if you'd like to submit a question, all you have to do is text 202-895-5599. You can see it there on your screen. We are going to be having your questions answered by our legal experts here live as we get them. So Frank and Tom, I do have some questions already that have been coming in. People texting them in. One of the questions that stood out to me, and we've talked about it a little bit at different points, the importance of Brenden taking the stand. Will he take the stand? And, what are the pros and cons? Why don't we start with you, Frank? What would be the pros of Brendan Banfield taking the stand here?
The pros of Brendan Banfield taking the stand.
Are there any?
Very limited.
Okay.
I would anticipate there is a close to 0% chance he takes the stand. There's just too much information, too many statements, too many inconsistencies for him to take the stand. Now, certainly that is the client's prerogative to do that. It seems like he has a good relationship with his defense attorney. I would anticipate that his defense attorney has advised him not to take the stand, especially how well the trial has gone from their perspective. So the pros of him taking the stand, very limited. Now, he does get to tell his side. And when you're in the courtroom, if you see a juror or several jurors that are staring at your client or looking like they're going to convict them, then you want to put your client up there on the stand to certainly tell his side of the story. He may overrule his attorney and decide to take the stand.
Okay.
But I think there are very limited upside to Mr. Banfield to take the stand. The cons are just way outnumber the pros, in my opinion.
Do you feel the same way, Tom?
I do.
Okay. Let me ask you a follow-up then. What are the cons, like the biggest red flags to him taking the stand for you if you're his attorney?
Well, it's a standard of law. Defense is there to show that there's reasonable doubt. Defense doesn't have to call a single witness, ask a single question. Of course, you're going to do those things, but you don't have to. You just have to show that there's reasonable doubt to what the state or the Commonwealth in this case is trying to prove. And if they can't do it, then you win. The jury's required to acquit at that point. But if you put your defendant on the stand, at that point, the jury tends, at least in their minds, to flip the burden. They start poking holes at what he's saying. Well, he's not credible. He's not telling the truth. And then they lose focus on what the standard of law is, and you have to try to bring them back in, and that's very difficult to do. So I would agree with Frank. I think that's about a less than 1% chance he takes the stand.
We've seen him taking a lot of notes. We've seen him making eye contact with various people. From our standpoint, we can't tell who he's looking at, but it looks like he's looking at the jurors. It looks like he was looking at Juliana when she was speaking, and he's holding that eye contact with whoever it is he's looking with. Do you think there was a conversation? I'm sure there was. What was the conversation that was had before between John Carroll and Brendan Banfield before they walk into that room each day? Do you want to start, Frank?
As we saw in the beginning, Mr. Banfield was kind of fidgety. His body language wasn't great, in my opinion. Covered his face a little bit, lots of note-taking, kept passing notes to Mr. Carroll, suggesting what questions to ask, the way I saw it. However, after Mr. Carroll began to pick apart Ms. Magalhães' testimony, and he did that over a course of a day, just in a brilliant way. Especially about her selling her story and what she's been through and that she's really the victim in all of this. He did a really masterful job on that. Mr. Banfield seems to have relaxed a lot, realized that Mr. Carroll full well knows what he's doing, and he seems to be backed off of his interactions with Mr. Carroll. So now he's more confident and he's looking around the room, he's looking at the jurors, he's looking at family members. I think he's feeling that this trial has gone as well as it could have been. Now, Jenna Sands, they're wonderful prosecutors, and they've been doing a great job with what they have, which is still a substantial case. So we'll see what they have left. But I think Mr. Banfield now is feeling his body language. You can see it, like this is going pretty well, and his attorney is doing a darn good job.
What about for you, Tom?
I agree with that, but I would also say I think he's been coached to do some specific things, and that is, if you watched the Johnny Depp trial, Johnny Depp, when Amber Heard was on the stand, could have looked up, could have reacted. He was there taking notes, keeping his head down, staying engaged, but not doing anything that could deflect the attention. And I think that he's done a good job of that. He's not done anything that would throw the train off the tracks, and that once again speaks to his lawyer and he interacting correctly, coaching correctly, that you don't want to become the focus of this trial. He was nervous at the beginning, he relaxed, he sort of got into a flow, because once the trial moves on, at that point it's more systematic. You sort of understand that it's part of a process.
Right, and you mentioned the word coaching, and I think we've seen a lot of coaching from Brendan Banfield, from the people taking the stand. How much coaching is happening as two people who are probably coaches at certain points when you're, at a trial? How much coaching is done leading up to the trial? Do you want to start, Tom?
I'll say we always coach on demeanor. Mm-hmm. We want our clients to come in wearing a suit, to act professionally, to be attentive but not emotional, just to be invested in the case, to show that you are the innocent person that you are and remain throughout the trial. Obviously, some clients like to be more involved. They like to write notes. They like to tell us something that they think is important. And of course, we lawyers look at those notes and see where they're going. But we just hope that they don't veer into trying to tell us how to do our job, because there's a fine line between a helpful client and a client who's trying to overtake the trial.
And I think the jurors can really see that when you're passing notes, as we saw. I think, we both, all three of us, noticed right away, oh, Brendan's passing his attorney notes. You mentioned to me last week a comment about John Carroll's suit one day. Can you talk about the outfit choices that were made? Whether it's Juliana's outfit choice, her hair was a different color. Were choices made there, and were choices made with Brenden and the outfits on the attorneys here?
There is a lot of coaching going on, and I think that's good. As we talked about last week, only a foolish attorney would call a witness and just ask questions and have no idea what that witness is going to say. I've certainly had a lot of federal cases where I've prepared clients and witnesses for hours, for days, sometimes multiple times. There is an opportunity sometimes to have a colleague cross-examine your client if they're going to take the stand. So there is a lot of coaching going on. There's also, as it gets down to the finer details, there's clothing choices. There's certainly the way you want to portray Ms. Magalhães from the prosecutor's perspective. Could have been completely innocent, but it seems like she came in to portray herself as kind of young, which she is, naive, unsophisticated. Now we saw that profile kind of deteriorate a little bit as she became testy and confrontational with Mr. Carroll. When he cross-examined her, and I'm not in charge of John Carroll's clothing attire, but he certainly came in with a very light suit, very gentlemanly, very scholarly.
You called it his trust suit.
His trust suit.
Yeah.
A friend of mine calls it, I'm going to wear Trust Me Brown today. And it's just the perception. You don't want to come in wearing a black suit with a black tie and really be ferocious. He came in with a lighter suit, lighter demeanor, but then his words were ferocious. His cross-examination was ferocious. And as we talked about last week, jurors tend to like the lawyers. They're still unsure about the witnesses. So when the witnesses start to give the lawyers problems, then the jurors really start to dislike that witness. And he did a really good job in a very trust me, light suit as kind of dismantling her testimony. And we'll see how the jurors actually react to her. If I'm doing the closing argument, my first line is reasonable doubt walked into the room when Juliana Magalhães walked into the room. I think that's what you're going to see from Mr. Carroll. Very direct, good points right away, and sort of just reinforcing what the jurors have already seen.
And you mentioned a similar closing statement to me as well. What would your closing statement be here?
I would talk heavily about the standard of law. I would compare the different types of law that you have and what that standard is, and indicate that that's still not enough to prove reasonable doubt. To prove proof beyond a reasonable doubt, I'm going to say, but essentially that's what I like to do. I focus on the standard of law, and then I like what Frank had to say about reasonable doubt walking in, I would say, and if that wasn't enough to show you that there's reasonable doubt, then you look at the science of this. They said the science was going to prove something, and in fact, it's helped our case. It's helped the defense's case.
So we do have another viewer question that kind of folds on what we were talking about. Somebody was asking, will closing statements be as short as the opening statements were? You're saying concise to the point. Do you think those closing statements will be as short as we saw, less than 35 minutes between the both of them, or do you think it'll kind of be longer this time? Do you want to go first?
I think it's going to be a lot longer.
Okay.
The defense only gets to speak once. So what I like to do is tell a jury, I only can come up one time. So because of that, I'm going to cover a lot more ground and just start poking at different things that didn't go the way the prosecution said they would go. And in particular, the cross was so good of the au pair. I think you could just do a chapter on that, essentially, just focus on that. She was not true about this in her recollection. She was not true about what she told you. This is not accurate, and just spend time on that, and then drift into the science, drift into some of the other areas. So I would just try to cover that whole universe, and that might take some time. But I don't want to bore the jury. I want to keep them focused that they can't prove the case beyond a reasonable doubt.
What about for you, Frank?
I think that's an excellent question. Really hones in on the juror's attention span and kind of where this case is going to go. Oftentimes in Fairfax County and in the state courts in Virginia, because the prosecutor gets to go twice, what the judge will do is apportion the time. The judge will say, listen, both sides have an hour and a half for closing arguments. As was mentioned, the defense only gets to go once, so that's an hour and a half of time. What I anticipate the prosecutor to do in this case, if they have, say, an hour and a half, they'll do 15 or 20 minutes in the beginning. Their first closing will be very brief. The defense will go on for an hour and a half, and then the prosecution will take an hour in rebuttal to refute what the defense has said. So in Virginia and in all courts, because there's such a high burden of proof, the prosecutor gets to go twice. And what I've seen oftentimes in Fairfax is they strategically just take a little bit of time in the beginning, and then in the rebuttal, that's when they really come in hard. And don't forget, we still have closing instructions to go. Right. And there's going to be some battles about some of the instructions that will go to the jury. The closings, to answer the viewer's question, will take a long time, but I expect the prosecutor to strategically split up their closing to gain an advantage in the case.
So another viewer question we have are about the objections. Early on, we didn't hear that many objections from the prosecution. It felt like the defense had more objections, and then we heard the judge weighing in and saying, hey, keep your objections to the point. One word objections, I believe, was her exact quote. She was getting a little frustrated with them. How important are objections? How important are they for the defense and for the prosecution? Do you want to go first, Tom?
I think they're very important, especially for the defense right now, because again, some of the objections you heard came when the prosecution was trying to put some summation, find a final point on some of the witness testimony. And in fact, they were able to shut that down. The witness, Ms. Dollygraph, was asked a question to essentially pinpoint what a lot of that testimony was about. And guess what? That was shut down on an objection. Sometimes judges just want you to say objection and say counsel approach and talk about the reasons at the bench. Sometimes the judge will say basis and ask you to put out what the basis is. John Carroll in this trial has raised several things when that has happened. He said, well, there's not enough foundation. They haven't built the question up in a manner in which they can ask the question. Or leading, you've heard that a few times. Leading means, for the viewers, that essentially the question's being put out for the witness to answer. They're saying, did you see any coats in the area? Yes, I saw a coat. Was it a red coat? Okay, that's an example of leading them down a road. They didn't say it was a red coat, you asked that. So a defense attorney would properly object there because they're trying to take them down a road for which they haven't provided the foundation.
Yeah, what about for you, Frank?
When you decide to object in front of the jury, the trial has just started. You want to win the first one. So I think you saw Mr. Carroll kind of wait on some of the leading questions, kind of let those go. But when he got to something where he was sure that it was going to be sustained, he won it. And you want to win that first one. Then the jury knows, well, wait a second. That other side is kind of pushing the rules a little bit, and the defense attorney or the prosecutor has kind of shut that down. So you want to win that first one. For the more substantive objections, where you are really explaining your objection, that's when you see the parties going up to the bench. One-word objections, which I'm glad the judge finally imposed the law on that case. Objection as to relevance, speculation, leading, hearsay, those are one-word objections. However, when it's more of the, wait a second, this expert is going beyond their certifications, beyond what they should be saying, that's when you see Mr. Carroll approaching the bench, because he's making more of a speaking objection. And you can see the judge and Mr. Carroll kind of have that good, as Matthew indicated in his report, they kind of have that good relationship. She's almost looking at him saying, I know you're about to object,
Right.
come on up. And the jurors see that. Who is the judge affiliated with in a, not a prejudicial way, but who are they respecting? Who are they talking to? Right now, both sides have good respect, and the prosecutors here are good prosecutors, but you can see Mr. Carroll is exerting a little bit of control over the courtroom.
Tom, let's talk about the bench. We talked about it earlier. We kept seeing the judge call everyone up to the bench. What is happening up there? Because obviously the mics are muted. We can't hear. What is that conversation?
Well, a lot of times it's sensitive information
Okay.
that the judge does not want the jury to hear. It's questions about things that have been ruled on in the past. Okay, we previously agreed you could ask these questions, but you're veering into territory you shouldn't veer into. Or this is going to take us down a road and I'll let you have some leeway, but it can't go past a certain point. So sometimes there are instructions that will happen then. And other times it's just very sensitive material that they want to talk about there, and maybe it's something that is not in evidence yet, but they're about to bring it in. So a lot of times that's what it is.
Okay. We're getting lots of viewer questions, so we appreciate that. Again, if you have a question, text 202-895-5599. I want to get to a question from Kim. She wants to know, why should the au pair get a plea deal when she is involved in the killing? Frank, you're up first.
They needed her.
Okay.
Sometimes you have to, from the prosecutor's perspective, as we talked about last week, when you do a bank robbery, for example, you don't do a bank robbery with a group of duns. You usually do a bank robbery with a bunch of bank robbers. So the prosecutor is stuck with a cooperator who is a bank robber, who may have a record, who may have a lot of dirt in his or her background. Who else are they going to call that would be able to give them kind of an eyewitness, has given them an eyewitness viewpoint? So in the defense perspective, maybe even the prosecutor's perspective, they kind of made a deal with the devil. And her attorneys did a nice job. They knew they had bargaining power. If you want to get a conviction on Mr. Banfield, you need my client. What are you going to give my client in exchange for her testimony? And they kept pushing. You saw she didn't make a deal until very late in this process.
Yeah,
They
a year
probably
later.
kept pushing and pushing and pushing, and finally she got a sweetheart deal. But they needed her. If they didn't need her, she'd be sitting there right with him, facing both charges and probably facing a life sentence. But they needed her. They had to do that deal.
We've talked a lot about her credibility. Another viewer question that came in: to the extent the au pair's testimony was not convincing, what can prosecution do in closing to get that, convincing completed?
They have to try to rehabilitate her somehow, whether they call her back on rebuttal, which they're able to do. If it's in closing and they don't use her in rebuttal, then they're going to need to say, hey, even if you didn't believe everything, here's what she said that is irrefutable. Here's what she said that you have to believe. And I think they're going to focus on the good and try to dispel some of the cross that was done very masterfully, by the way.
And I think what they will probably say is, does it make any sense to you that Ms. Banfield went on a FetLife website and perhaps an upcoming witness may comment perhaps on her background or her situation. Does it make any sense to you that she went on a FetLife website, set up this whole scenario, and this went down in this manner? Does that make any sense to you? So they may put the au pair's testimony kind of aside and say, yes, there are some problems with it, but does it make any sense to you when you're putting this picture together? Don't leave your common sense when you walk into that juror room. Don't leave your common sense out in the courtroom. Take it into the juror room. The defense perspective, the defense, it may not make any sense that she put this ad on a FetLife website and kind of set up this type of fantasy situation, is my opinion.
Let's revisit that in just a moment, because I know you have a lot to say on that, Tom. In your opinions, how crucial are the details of the affair to this murder charge? How crucial are those details? You want to go first, Tom?
Crucial. It affects the character. It's sort of an end around into character of Brendan Banfield, that he had a motive for this, that he plotted this, the picture that was changed that has the two of them together, it just fits the image of what they're trying to convey that he really is. So I think the affair is very difficult for them.
And what
the
about
defense.
for you? What about for you, Frank?
I think having probably done close to 100 jury trials, there's usually an exhibit list that comes out before the trial that you look at, the government's exhibit list. Then there's always 4 or 5 exhibits on that list that you say, wow, I really wish those had not been there, that those had not taken place, that I'm not going to have to deal with that. The picture of the two of them together
Just a few
in the
months
bedroom,
later.
problematic. The picture of her at a firing range, you don't usually take your babysitter to a firing range, problematic. If I'm Mr. Carroll and I'm looking at that exhibit list, those few pictures, not only dirtying him up with an affair, but those substantive pictures of the two of them together, her at a firing range, that's problematic for the defense. Even if you put her testimony aside for the most part, those photos are a problem. I expect Mr. Carroll has an explanation for it, and we'll see exactly how he portrays it to the jury in closing.
I want to follow up on
Yeah.
that. I think that it goes to the type of learner or listener that each juror is. Some people listen with testimony. Some people are more visual listeners or visual learners. And I say that they hear the testimony, but they're looking at the picture and they're coming to their conclusions based on what is there. So they're listening, but they're really a visual learner. They're really someone who is considering that. And when they're looking at the picture, they're processing it differently than somebody just listening to testimony. So for that, it's very important to get those pictures out if you're the prosecution, and for the defense to try to find ways to minimize them. And that's going to be difficult to do.
You know, in addition to seeing those photos on the nightstand, we also saw this very lengthy conversation between a profile called Anastasia, which, you know, the defense has said was Christine. The prosecution has said was Brenden and Juliana posing as Christine. Do you believe, let's start with you, Tom, do you believe that the prosecution has done a good job of proving that it was Brenden and Juliana behind that conversation between Anastasia or Christine and Joseph Ryan?
Yes, I do, because in order for the jury to believe that it was, in fact, not Brenden and the au pair, they'd have to have something showing that there's this double life going on. And so far, we haven't heard, the defense would have to do that, but we haven't heard that that's going to come out, and the prosecution hasn't addressed that, well, she's had this double life and blah, blah, probably because it doesn't exist. And I think that they've done a good job showing that the motive here is those two. There's nothing to believe this is who she was. So the defense is really going to have a hard time with that. I think the website, the fetish website, the planning, the plot that the prosecution is arguing, I think that's really, that in the pictures, that's really some of the best part of their case.
What about for you, Frank?
We'll see. Remember, in some pretrial litigation, there was a lot of controversy about what the forensic signature, for lack of a better term, demonstrated. It seems like some of the preliminary conclusions were that perhaps it was her forensic signature on her laptop. There was some controversy about that, and some of the officers in the case were either reassigned or perhaps went on to different duties regardless of their conclusions. So there was a lot of talk about that pre-trial. I would expect that Mr. Carroll may have a forensic expert that's going to come in to say, listen, from everything that I've seen from her laptop and her forensic device, her electronic devices, forensically speaking, it's more likely than not that this was her signature with regard to this website and some of the things that were found. We'll see whether he calls an expert on that. It's been kind of outside of the testimony so far, but it wouldn't surprise me if you see some testimony on that to refute those very strong points that I think the prosecutor is going to make.
I will bring up again, though, you know, we heard in the opening statements, John Carroll said that forensics don't lie, people don't lie, kind of setting the stage of Juliana, in his words, is the liar and the forensics are the truth. So, you know, we haven't really seen forensic evidence showing who was in control of the phone, just screenshots. What kind of evidence are you trying to gather as a defense attorney for Brenden to try to prove that it wasn't Brenden and Juliana? Do you want to go first, Tom?
I think what you want to do is muddy the waters, and anything that you can find through investigation and witnesses who could, as you heard already, experts who could come in and say, well, it's muddied, it's not clear, it's this. I think you're looking for all of that. As far as what we've heard, the forensics, the DNA, the fact that there was not a determination on the DNA as to who that was. Was it Mr. Ryan? Was it Mr. Banfield? We don't know. And that is a huge issue, and that goes to the forensics don't lie. The DNA doesn't lie. You can't tell. The expert said you can't tell. I think we're going to hear a lot about that.
And I think given how cautious Mr. Carroll was in his opening, the one thing that he said was that people can lie, forensics don't lie. I would expect him to back that up. He's said it to the jury in opening, in a very brief opening. I wouldn't expect that he would say that and then have nothing to back it up. That's why my inclination is you're gonna get an expert witness on the defense side. We'll see.
You know, we still have 2 weeks, 3 weeks left for this trial. I know neither of you believe it's going to last that long. What do you think we can expect to see happen really just in the next few hours? You know, the prosecution has one more witness supposedly to call after the defense asks their questions of this current witness. Do you expect that to continue into the end of the day for the jurors today? Let's start with you, Frank.
I would expect the prosecutor to probably wrap up their case either later today or first thing tomorrow. After that, in Virginia, the defense will then make a motion to strike, which essentially the jury is removed from the courtroom, and the defense attorney will say, we move to strike the Commonwealth's case at this point. The problem with the argument is going to be that the standard at that point is not proof beyond a reasonable doubt. It's giving the Commonwealth every favorable inference. Have they established basically a prima facie case? Could any rational juror reach a conviction in this case? It's a very high standard for the defense to then argue that no, they haven't, and this case should be dismissed. I would expect that Mr. Carroll is going to make that argument. I don't think he'll put everything out there in that argument. I think he'll give kind of an outline of that argument. What he's really trying to do is get the prosecutor to talk. He wants the prosecutor to talk at that point and highlight kind of her strongest points in the case, so he can kind of get a preview of her closing statement. So after they wrap up their case, the prosecutor wraps up their case, he'll do a motion to strike, and then the judge will say, are you ready with your own defense witnesses? Who do you intend to call? I would expect by tomorrow afternoon, if the defense calls anybody, that's when they're going to start presenting their case.
Sometimes the judge can tip it off and say, does the defense wish to be heard on this?
Right.
Meaning, I already know how I'm going to rule, but is there anything you wanted to bring up? And it really is sort of a fishing expedition to find out what the Commonwealth is going to argue.
Yeah.
Because the judge knows that the court's not going to rule that the prima facie case wasn't met at that point because of the standard.
Right. Thank you both so much. It does look like court is starting up again, so we are going to take you back into the courtroom.